Welcome back. You're watching HFO-TV. HFO-TV is co-sponsored by the construction, repair, and restoration firm J.R. Johnson, the real estate law firm Baljanik LLP, the tax deferral accommodator Butler Exchange Group, the mortgage banking firm Gantry Incorporated, and forensic building consultants providing building structural science services.
Welcome back to HFO TV. I'm Greg Frick, partner at HFO Investment Real Estate. We're here talking, it's the end of June 2021, and we're lucky to have Brad Kraus, attorney at Warner Allen, back with us again, an expert in landlord-tenant law. And Brad, I know Governor Isley in Washington just signed a new proclamation. I'm not going to put you on the spot. You haven't a chance to go through it, so I think we'll be safe to say we'll get back with you in the next week and get something out regarding that. Again, we're at the end of June. It just happened. So again, it's the way stuff has been going in landlord-tenant law. You got to read it first because the way they're written, it's sometimes causes more confusion than it solves.
It does, and just a couple of highlights in terms of so I can give the audience a little bit of something. It's supposed to act as a bridge to allow a lot of these counties to implement programs, rent assistance programs, and ERPs. It effectively prohibits evictions, not evictions, but service of non-payment of rent notices, and in other cases, some notices that are based in whole or in part due to arrears that due to COVID, until there's been an ERP program established and a rent assistance program established. So that's going to create some pushback, obviously, until at least August. So that's one thing that is kind of a highlight. The other thing that it does, consistent with Inslee's other proclamations, it effectively requires that a landlord is prohibited from treating any unpaid rent or charges as an enforceable debt unless they offer effectively a repayment plan and go through a rent assistance program and an eviction resolution pilot program consistent with 5160. So that presents a challenge there as well. Late fees, no late fees through September 30th of 2021. That's another big thing. The oddity of that is that seems inconsistent with 5160 because 5160 effectively prohibits late fees from the rest of the year. So there is some inconsistencies there.
That's not surprising, though. That's not surprising. We get a lot of inconsistencies.
The other important things that folks are going to want to know is that there is an opportunity now for rent increases to occur commencing July 1, but there's some ambiguity as to when those could be effective just based upon the poor wording in the proclamation. The conservative approach for rent increases based upon that poor wording is that they would go into effect October 1. So that's the conservative approach. That's what I'm going to be talking with my clients about in terms of rent increases if they are inclined to serve those. So that's effectively it. The other big thing is that other evictions, conduct-based evictions, those are back on the table now. So the proclamation now removes sort of the immediate significant risk factor that was in place before. And so conduct-based notices, they're back on the table starting July 1. If your tenants are making a bunch of noise and smoking in violation of the rental agreement, those sorts of notices are back in the fold.
Again, and that's the state of Washington, not Oregon. So again, we'll get back with Brad once he's had a chance to kind of review that, kind of get the that was kind of a high level, more of the ins and outs on how people in the state of Washington are going to work through this new proclamation from the government just signed, from the governor just signed today at the end of June. So let's hop across the river and talk a little bit about Oregon and House Bill 1236 that got signed into law middle of May, and kind of give an update of where we are in that in that realm of landlord-tenant law in the state of Oregon.
Yeah, so in Oregon, what we're working with is Senate Bill 282, and then recently passed Senate Bill 278. 282 goes into effect July 1, so the The previous version of the eviction moratoria, House Bill 4401, is going away. So sort of a high level overview of 282. Obviously, there's the grace period extension. So effectively COVID protected amounts, April 1 through June 30th. So through today, those are protected by a grace period. Those are not due until February 28th of 2022. So effectively March 1st is when those things will become due and owing. Creates some prohibitions with regard to reporting of those amounts to credit bureaus, and also prohibits residential landlords from screening prospective tenants based upon those COVID amounts. And it allows defendants to seal, set aside judgments of evictions based upon claims that arose during that period. That's not really too unique. And then finally, the bigger thing with Senate Bill 282, and this is the one of the bigger pieces of it, along with the grace period, is that it creates certain restrictions on what a landlord can do with a tenant's guests. So that the unauthorized guest dynamic is changing, and it has changed since 282 went into effect.
And this all comes into effect July 1st. Well,
so the a lot of the fiscal items are in effect on July 1. So right. Tomorrow they'll all go into effect, but effectively right now, for all intents and purposes, they are in effect. The guest prohibition items, those are currently in effect. Those went into effect upon passage. And that creates some interesting issues with regard to how landlords can act and approach unauthorized guests and their tenants with regard to unauthorized guests. Happy to dig into that a little bit more here as well.
Well, yeah, why don't we do that? Because I know that's been a question that's come up a lot of times with a lot of property owners. You know, I've got a tenant that's got an occupied guest during COVID. What I cannot do? It's, you know, with this kind of protections, where does that lay? So yeah, maybe we can dig a little bit into that, and we'll talk about a few other things that have come up too.
Yeah, so the big prerequisite here, and this is sort of talking about the rights of a landlord, and the big prerequisite now, as landlords are used to, they have a lot of landlords in their forms. They have, if a guest is here, more than 7 days in any 1 month period, or twice that amount in any 12-month period, then they're an unauthorized guest, right? And obviously that's a proof issue, right? So in order to prove that person would be an unauthorized guest, you would have to prove, they were there above and beyond that. Similar to this, Senate Bill 282 says if a tenant's guest resides in the dwelling unit for more than 15 days in any 12-month period, then the landlord's rights kick in. So again, it's that 15-day threshold that the landlord will have to get over to eventually be able to serve a for-cause notice based upon a couple of the factors that I'm going to talk about here in a second. So if a tenant's guest has been there for more than 15 days, then the landlord can require that the tenant's guest be screened, subject to whatever criminal screening they have. Can't screen them for financial or anything like that, so keep that in mind. And two, they can require the tenant and the tenant's guest to enter into a temporary occupancy agreement, and that statute would be 90.275. So
that's after 15 days. That's after the, yeah, okay.
Yeah. Yep. So after 15 days, the tenant can say, hey, tenant, you have a guest that's been there for longer than 15 days. I know they've been there for longer than 15 days. And again, that's that proof issue. I know they've been there for longer than 15 days. So I'm going to require that they be screened. And I'm going to require that they enter into a temporary occupancy agreement with you and myself. And if the tenant's guest says, no, I'm not going to be screened, well, now it's a for-cause notice situation, because the landlord has rights subject to 282 that once that guest is there beyond that period of time, they can require that person to be screened. If that person says, no, I'm not being screened, or if they fail that screening, the landlord can then require them to be gone pursuant to that for-cause notice.
And do you have to give the guest that's not on the ability? Do you have to give them the option to get screened, or can a property owner say, you've been here for 16 days, we're going that other route, or is the way it's written? Do you have to say I need to screen you? Then if they say no, then you go that step.
Well, the important thing to remember is that landlords can apparently no longer make them leave just by service of an unauthorized occupant notice like we used to, right? If a tenant used to have an unauthorized guest there, we'd serve them a notice, say, hey, you got somebody staying there that's not there, they have to leave. That's not an option anymore unless the landlord invokes these rights and the tenant or the tenant's guest doesn't cooperate and or fails the screening. So consistent with a lot of other COVID moratoria, and Washington saw a lot of this, some of their local jurisdictions had put into place restrictions on basically the ability to remove guests. It's similar to that here, except the landlord has some rights with regard to that unauthorized person. They can require them to pass criminal screening. And if they do, that is what it is. The legislature says they get to stay. Keep in mind that anything that the guest does in terms of conduct, in terms of breaking the rules, that does fall back on the tenant. So it's not as if that guest can come in, start smoking a bunch, make a bunch of noise. All of that conduct falls on the tenant. So they don't get to have a guest come in there and tear the place apart. Similarly, it doesn't mean they're a tenant. Acceptance of a payment from the tenant or the guest doesn't create a tenancy with that unauthorized guest who's now become, they now get to stay there pursuant to, a temporary occupancy agreement, which is another thing I would encourage landlords to require if they're going to, if somebody has an unauthorized guest.
Gotcha. And I would encourage everybody, if you're going to go this direction, get legal advice. Make sure you've got, somebody giving you advice on how to handle this, from notice provisions to all steps through this thing. Because again, it's there's a lot of bumps in the road you can hit, and we got to make sure that you're doing things correctly. So, what are some of the other things? I know you talked about you can't in terms of screening, or you can't hold. Is there a sunset to when you can't report things to credit agencies, or is it once February comes and the tenant's made a payment plan and it doesn't work out? What's the obligation of the landlord in regards to that?
So a lot of these things, they sunset a ways down the road.
Okay.
And I think I can't remember exactly what the bill says. I'm taking a look here. I think it's 5 years from now. I think some of these screening considerations, that's when they sunset. So it's a ways down the road, but some of these provisions, like the unauthorized guest provision, that's repealed March 1st of 2022.
Got it.
So it's not an indefinite thing. The unauthorized guest prohibition and requirements of landlords is repealed next year. So that's a temporary thing. Obviously, the grace period going to effectively February 28th of 2022. That's another big one, because then after that, then landlords are allowed to file an action for any unpaid amounts. That's another big thing. Report to credit agencies and the like after that time.
And that's a grace period, Brad. That's a grace period just for rent due through June.
Yeah, so effectively think of it as I always like to call it the COVID amounts.
Okay.
So it's not just rent, it's also utilities and things like that as well. So those COVID amounts are effectively protected now through effectively February 28th of 2022. And the kicker to that is pursuant to old law, House Bill 4401, tenants would have had to give you a declaration in order to make that a thing. Now they don't have to give you a declaration in order to get that grace period. They get it no matter what.
Got it.
Okay, so that's a change from 4401 to SB 282. Effectively, every tenant gets the benefit of that grace period.
So there's no declaration for a tenant to invoke that grace period. It's automatically included in, however you want to say it. Okay.
Automatic, but then so it's important to remember that the other new law, Senate Bill 278, which we'll talk about in a second, there is a verification requirement there to invoke the new 60-day stay that tenants can invoke pursuant to that bill. So that's the other new bill that just went into effect recently.
So yeah, let's talk a little bit about that one. The one that, because I think everybody saw that in essence, the moratorium, got extended for 60 days in Senate Bill 278. So the nuance on that is there needs to be some action by the tenant to invoke that?
Yep. So the big thing about Senate Bill 278, this is sort of the higher level overview, is that rent is due in July, rent is due on time.
Okay.
End stop. Okay. Rent is due on time in July. If your tenant doesn't pay your rent, then come the 8th day of the rental period, then you would be allowed to serve them a non-payment of rent notice. It would be a 10-day non-payment of rent notice, because that prohibition is still in place, the 10-day. We're not rolling back to the 72-hour notices until next year as well.
Got it. But again, we're not dealing with rent that was due based, like you said, the COVID period. What's the stuff that was due from June back? That's the February.
That's all protected.
That's okay. Got it.
We're just talking July's rent.
So moving forward. Okay.
You could only serve that non-payment of rent notice for July's rent.
Gotcha. Okay.
So the thing about Senate Bill 278 is it creates an odd sort of if this then that proposition, and it really depends on where you are in the process. So let's say, for example, we're at July 5th, okay, and your tenant provides you that documentation, that verification that they have applied for rental assistance. That's the trigger in 278. The documentation that they have applied for rental assistance, not that they've been accepted.
Just applied.
They've applied for rental assistance. Yep. So once they give you that information, okay, then there is a 60-day, effectively a delay or a stay that goes into place. If you have not served a non-payment of rent notice and you get that verification, then the landlord is prohibited from serving or acting on a non-payment of rent notice for that 60-day period, okay? The second sort of if then, so let's say the landlord has served a non-payment of rent notice. So let's say we're at July 10th and the tenant then provides you with that documentation. Well, the landlord cannot file an FED on that notice. Then they would be prohibited from filing an eviction action based upon that notice. That 60-day timeline would kick in, that 60-day delay. And if the tenant, if they get rent assistance and obviously it covers that time frame, then great. Then that moots the whole thing. If no rent assistance is acquired, then effectively the landlord probably is going to end up serving another non-payment of rent notice for all of that time frame, so that the July's amount plus the 60 days after the fact, right? Because then August and September, I would advise my clients just to serve another 10-day. And they only get one 60-day stay, just one. So they get one opportunity at that 60-day stay, and that's it. All right. And then, so if the landlord serves a non-payment of rent notice, nothing's received, no documentation, no rents received, and they file an FED. So let's say they file the eviction action. If the tenant provides you that documentation during that process, then a 60-day basically set over or stay would go into effect pursuant to that first appearance, that eviction action. And if no rent assistance is received after that 60 days, then the landlord can continue with the eviction.
Just keep going forward. But you've got a 60 days if the tenant has applied for rental assistance. Not received it, just has to show proof of applying.
Yep, they've got to show you. Yep, they've got to show you that they have applied, that they're actively applying for rental assistance. They've applied for it, and if the landlord gets that rent assistance while that eviction is in place, if they get rent assistance, then they have to dismiss it.
Gotcha.
So
okay.
So that's kind of that's a lot of wording. That's a lot. It needs a flow chart.
It's always something new. It's never static here in this realm. So, well, thanks for kind of doing a higher level explanation on that, because I know that a lot of people were questioning as they saw that come through, and the eviction moratorium got extended 60 days. There is something that the tenant needs to at least apply. And then, as I said to the audience, we'll get back with you, next week and talk a little bit about, what happened in the state of Washington as if you had a chance to dig through there. As you and I have both said again and again, people that are listening to this, it's a different ballgame now. Get legal advice when you're dealing with, landlord-tenant laws. It is not. There's a lot of gray areas, a lot of interpretation, and I can't stress that enough. That's the direction we highly recommend with everybody.
I want to stress one more thing for the audience, Greg, for everybody that's listening. Update your forms.
Yes.
Okay.
Yes.
Your old forms are not going to cut it anymore because pursuant to Senate Bill 282 and Senate Bill 278, there is new disclosures that need to be in your notices. Okay. So update your forms. Your old forms from 2020 and 2019, they're not going to cut it anymore. And they're going to be invalid. They're going to be fatally defective. And you may have some problems there if a tenant's attorney shows up. So update your forms, please.
We will get that out to the audience as well. Thanks, Brad, for taking the time to do this. Be safe, and we'll be talking to you next week. And we'll see you again on HFO-TV. Thank you.
Our entire office specializes in multifamily real estate, making HFO the largest multifamily brokerage in the Pacific Northwest. Your success is our passion. Build your legacy with HFO. Call 503-241-5541 or visit our website at hfore.com for more information.